Additional considerations in seller representation. In various regions of Arizona, standardized listing agreements are provided by boards and MLS systems, as detailed in the preceding sections. Typically, these agreements fall into two categories: exclusive rights to sell or exclusive agency. Some MLS systems utilize a unified agreement for sales, leasing, and vacant land, while others differentiate between residential sales, residential leasing, and vacant land sales. Regardless of the specific agreement type, there is a commonality in language concerning seller representation and the compensation offered to the listing broker. Irrespective of how the buyer's agent represents the buyer, the listing agreement often grants the seller the authority to determine the compensation for the buyer's agent. In certain instances, the seller may delegate this determination to the listing agent. The subsequent scenarios delve into several issues prevalent in our industry. One such scenario involves a breach of contract by the buyer, leading to forfeited earnest money. In the past, listing agreements stated that brokers were entitled to half of the forfeited earnest money, provided it did not surpass their total commission at closing. However, recent changes in most MLS systems specify that this entitlement pertains only to the listing broker, excluding the buyer's agent. Consequently, if the buyer forfeits their earnest money, their agent generally cannot claim any portion of it. The specifics may vary based on the boilerplate language in the listing agreement, but it is crucial for buyers' agents to recognize that the listing agreement is a pact between the seller and the listing broker. Therefore, the buyer's agent lacks legal standing to enforce terms or conditions outlined in the listing. Some listing brokers choose not to assert a claim on forfeited earnest money, allowing the seller to retain the entire amount. This decision is a business choice made by the listing agent and their broker. The MLS systems modified the rules to restrict claims on forfeited earnest money exclusively to the listing broker, excluding the buyer's broker, acknowledging the listing broker's authority to make such decisions. Rejecting a full-price offer doesn't impose an obligation on the seller to accept it, contrary to a long-standing myth about the necessity of accepting what was termed a mirror image offer. This misconception suggested that rejecting such an offer would result in the seller owing a commission. However, it's essential to dispel this myth, as legally, there is no concept of a mirror image offer. Sellers have the freedom to reject any offer, regardless of price or terms, without being compelled to pay a commission. While the MLS may indicate the price the seller is willing to consider, offers may contain unexpected contingencies and terms. The list price offered in the MLS is just that, an offered list price. Sellers are not legally bound to accept an offer at that price. For instance, if a seller receives 4 offers, all at the list price, they may choose to accept one and reject the other 3, or counter all 4 at a higher price. Regardless of the seller's decision, they are not obligated to pay a commission on rejected offers. When a seller breaches a contract nearing closure, they enter a legal realm where they are bound by 2 contracts, one with the buyer for the property's sale and another with the broker, obligating them to pay a commission if the property sells. Listing agreements often stipulate that the seller owes the commission even if they prevent the closing or take actions hindering the sale's completion. In the event of a contract breach, the seller would indeed be required to compensate the listing broker. To collect this compensation, the broker may need to initiate legal proceedings, beginning with a letter demanding payment and potentially escalating to litigation in court. Pursuing legal action might be necessary for the broker to obtain the compensation owed. In cases where a seller is willing to risk legal consequences from a ready-to-close buyer, they may breach the listing agreement and refuse to pay the broker. Wheel title. What might be necessary for the broker to obtain the compensation owed. Phrase, pursuing legal action. What happens to the buyer who wants to buy the home? Sellers may cancel a contract because of seller's remorse, a death, an illness, the loss of a job, or they cannot find a home to purchase. They should have done a contingency then, to protect themselves. What is the buyer's recourse if the seller cancels? They would just get their earnest money returned to them. If the buyer wants to pursue to purchase the home, they can go to court and file a lawsuit for specific performance. It is an expensive process. Considering the scenario presented, let's hypothetically suppose that the broker pursued the seller for the commission specified in the listing, which we'll assume to be $9,400. In this hypothetical situation, the broker could take legal action in justice court for any amount below $10,000. If the broker were to win the case, or if the seller agreed to a settlement and paid the broker $7,000, a question arises. The answer is likely no, or perhaps more accurately, probably not. The listing agreement does not stipulate any obligation for the listing broker to share proceeds from a lawsuit. Moreover, for the purposes of the contract, the buyer's agent is not a party to the listing agreement and therefore is not entitled to any compensation. It's worth noting that if the broker secures a court-ordered award or a settlement, it's technically not considered receiving a commission. Here is a recount of a case from the mid-1990s where two agents collaborated throughout a transaction. However, a few days before the close of escrow, the seller unexpectedly decided not to proceed with the closing. Despite efforts from the listing agent, the listing broker, and the seller's attorney, the seller adamantly refused to close. Facing the threat of a lawsuit for the $24,000 plus in commission, the listing agent and broker pursued legal action. Subsequently, prior to the court hearing, the seller proposed a settlement, ultimately paying the listing broker $16,000. In an unusual move, the listing broker then shared half of this amount with the buyer's broker, even though there was no strict obligation to do so. As an additional note, the seller also reached a settlement with the buyer for an undisclosed sum. The buyer asserted a loss close to $100,000 due to expenses incurred in attempting to purchase the property, legal fees, and the foregone potential profit. Given the seller's breach of contract, they had a clear obligation to compensate the buyer. Know what you are doing during the escrow period and watch for red flags should any come up. Legal issues are not fun to go through. Regarding FSBO, or now called unrepresented sellers. The seller is a for sale by owner, FSBO, and is reluctant to pay a commission. We do not call them FSBOs anymore. We call them unrepresented sellers. As a buyer's agent representing your client, the question arises, should you approach a FSBO property? Imagine you're showing properties to your buyer, and amidst MLS-listed homes, you spot a FSBO sign on a house resembling others in the community. What's your course of action? In the absence of an exclusive buyer or broker agreement, you might decide to ring the bell and initiate a conversation with the seller. Your initial inquiry could be, would you allow me to show the property? Assuming the seller consents but refuses to pay any commission, you face a dilemma. Now you are in a pickle. You represent the buyer, but without a prior agreement, there's no guarantee of compensation, as there is no buyer-broker employment agreement in place. Do you proceed to show the property to your buyer, adhering to your fiduciary duty, or do you pass it by? This predicament underscores the importance of having your buyer complete and sign an exclusive buyer-broker agreement. With the agreement in place, you empower the buyer to decide. If they express interest, you can inform them that purchasing the property would entail a commission obligation if the seller is unwilling to pay a commission. This approach gives the buyer control and may influence their offer accordingly. Without a signed agreement, showing the property to the buyer becomes a commitment, acknowledging the possibility of not getting paid if the buyer proceeds with the purchase. It poses a challenging decision for many licensees in such situations. You should pull the car over and have a heart-to-heart with the buyer and have them sign a buyer-broker employment agreement prior to showing the property. If the seller agrees to pay you something, that would be credited to your buyer's agreed-upon percentage or flat amount. Moving on to exclusive agency, EA, listing agreements, the question arises, can the seller market the property as a FSBO and find a buyer independently? Indeed, under the EA agreement, the seller has the flexibility to market and sell the property without an agent's involvement. However, this introduces complexity, as you, the agent, still represent the seller, and the broker's stance on such listings can be a factor. While some brokers might reject EA listings due to their potential confusion, many sellers prefer having the freedom to sell to specific individuals without paying a commission. If your broker prohibits EA use, you may resort to an exclusive right, ER form, noting those individuals by name as additional terms. Even if your broker has no preference, using the ER with named individuals and seeking approval is advisable. Importantly, if you agree to such terms, it is reasonable to request compensation for these specific circumstances, ensuring that your fiduciary duties are appropriately considered and valued in the transaction. If the seller does find a buyer on their own, with the EA intact, do you need to represent the seller in this transaction? Well, that is up to the seller. If the seller says they want you to represent them, make sure you and the seller are in agreement about your commission for services. If the seller does not want to pay you because they say they found the buyer, however, they want you to represent them and complete all the documents and forms required to complete the sale, you would have a heart-to-heart with them and let them know you do not work for free. Remember, you have value. When talking to a FSBO seller, we now classify them as unrepresented sellers, making sure they understand that for sale by owner properties may not get what they think is a better deal than paying an agent's commission for their services. They have less exposure to more buyers. Bargain hunters will offer less as the seller is not paying commissions. The seller is also showing the home on their own, which could be dangerous, as there is not agent with the buyer that has been vetted.